Good morning, everybody. This is Mary Beth LeBate, president of CICU. Thank you for joining us, and I hope all is well with you, your community, and your loved ones. I know it's a very difficult time. I'm going to just start this off by introducing our colleagues from Cullen and Dykman, who have been gracious enough to offer this webinar to us. CICU, Cullen and Dykman, has been a long affiliate of CICU and does great work with us, and I know works with many of our, provides legal counsel to many of our schools. So we have about 200 people registered for today's session, and so I want to get started. Let me introduce our colleagues from Cullen and Dykman who are with us today. Tom Wassel, Hayley Dreyer, and Jim Ryan. What we'll focus on today is the impact of COVID-19 on the workplace. They'll go through their presentation, and I think there will be some time at the end for some questions and answers. So with that, I'd like to hand it over to Jim.
Thank you so much, Mary Beth. We really appreciate it. And good morning, everybody. A sincere welcome to this webinar. As Mary Beth mentioned, I'm Jim Ryan, a partner at Cullen and Dykman, and along with my partners, Tom Wassel and Hayley Dreyer, we're going to go through the effects and ramifications that the various new laws and executive orders have had on the workplace. But before getting there, just to give everyone a quick perspective of how fast things have changed. Exactly 1 month ago, the economy had added 273,000 jobs, and unemployment was at a 50-year low. Today, the jobs report indicated that 6.6 million people applied for unemployment benefits just last week. So in a 3-week period, it shifted that many jobs. That number is expected to rise in the coming weeks. That number also masks the thousands of people who have been physically unable to apply for job benefits due to jammed phone lines, website crashes, and obviously the physical closure of the unemployment offices across New York and other states. That number reflects layoffs, furloughs, hour reductions from all types of employers: airlines, hotels, restaurants, law and financial firms, and banks. And unfortunately, colleges and universities are not and have not been immune to the impacts on the workplace. The COVID-19 outbreak has dramatically impacted colleges and universities of all sizes. As a result of the pandemic, many institutions are considering or have already been reducing their workforces. At the same time, our institutions are being inundated, literally almost daily, with evolving federal, state, and local laws, regulations, and executive orders that are coming at breakneck speed. Both the federal and New York State government have enacted legislation mandating job-protected sick leave and other forms of leave for employees who are unable to work or even telework. Organizations are being called upon to quickly understand this rapidly developing landscape and adapt to how it impacts the wide-ranging campus community. This morning, from the makeshift offices we all have created in our kitchens, dining rooms, basements, or other free spaces within our homes, we will discuss how to navigate and prepare for these issues. We will be specifically discussing the government actions to date, how these actions have financially impacted employers, the recently enacted leave policies and paid sick leave policies, and if time permits, we will give a very brief overview of the last week's $2.2 trillion CARES Act and some of the potential avenues for financial relief for your institutions. This is a historic period in our country's history. We share your concerns. And our hearts obviously go out to everyone who's been negatively impacted by this pandemic, and those of you who face difficult choices in the near future. We know these days are incredibly stressful and unnerving, but please give yourselves a break. We are all making the best decisions possible with the information that is available at the time those decisions are made. CICU is a fabulous and great resource. We'll all get through this together. And so without further ado, I will turn it over to Tom.
Thanks, Jim. This is Tom Wassel, also a partner at Cullen and Dyckman. And I look forward to speaking to and working with all of you. We're going to focus on a few different items today, as Jim mentioned: governmental actions, financial impact institutions, some of the recent leave laws, and we'll, again, going to try and leave some room at the end for Q&A. Obviously, we want to talk about what you want to hear about. Now, in terms of what the government is telling us to do, and I'm probably not going to be telling you something you don't already know. The CDC wants everyone to focus on 3 general areas: limiting the transmission of COVID-19, which is, of course, the official name of the coronavirus, talking about continuing your business operations, and how to maintain a healthy workplace environment. The limiting the transmission, of course, and you're going to be learning, or you've already learned about this term, flattening the curve. That's what we're trying to do by limiting transmission. And the point of this, of course, is not that we're going to cure the disease or stop the disease from spreading entirely. The idea is to try and not overwhelm the healthcare system, which frankly is already being overwhelmed in many places. So far as of yesterday, according to New York State, there are 83,712 cases in the state of New York. More than half of them are in the city of New York, over 47,000. And every county in the state has reported cases of COVID-19. The idea is to at least slow things down so that when people do get sick, and they will, and of course people get sick for other reasons as well, that hasn't changed, that our healthcare systems and our frontline workers in the healthcare system can try and help as many patients as possible and do so as effectively as possible. So in order to try and achieve those goals, some basic guidelines from the CDC, which of course have been amplified by governmental orders, which we'll talk about in a little bit, is if employees feel sick, they should go home. This is probably not a big issue for most of the people on this call right now because most of your employees have already gone home, but they will be coming back to work at some point. If there is a positive result, or a person who has tested positive for the disease, identify where that person worked. And that site may need to be cleaned and disinfected. Identify who that person worked with. And by who they worked with, it's not a question of if anybody they ever walked past, but who did they work with on a regular basis, spend more than 15 minutes with, because that's how the disease is generally spread, through touch or through breathing, and where other people can inhale particles from other person's breath. So that's how we have to try and remove the spread of this disease. At the same time, the Americans with Disabilities Act still applies. Now, the ADA contains provisions that limit your ability to talk about diseases or illnesses that other employees have. Some people incorrectly, I've had some clients incorrectly suggest that they have a HIPAA concern. That's not the right, there is a concern, but it's not HIPAA. HIPAA only applies to healthcare organizations and those who are maintaining healthcare information. But the ADA still definitely does apply. And of course, under New York State guidance, if there's an employee who tested positive, that person should self-quarantine for 14 days. And we'll talk a little bit later about the difference between a self-quarantine and a quarantine that's suggested or mandated by either a doctor or by areas of government. We suggest that someone in your organization, the coordinator, or the COVID czar, if you wish, someone who can be the quarterback of all of your institution's responses on COVID-related issues. Many of you, and in the area of higher ed, your leave policies and your benevolence towards your employees is probably greater than that in many industries, but you're encouraged to have flexible leave policies, to work with the employees. For some of your employees, that is possible. For some of them, it is not. And we'll be talking a little bit later about what the government requires you to do. You have to determine what functions are essential and what functions you can do without. You have to figure out what to do if you start losing employees, whether at home or on site, because they're unable to work, either because they're not able to telework or because they are too sick to work. And of course, there's that great term, social distancing. Those of us of a certain age can remember 20 years ago, we all learned a new term called the hanging chad. If you're too young to remember that, ask somebody older than you. Now we've all learned this term, social distancing, which basically means stay away from other people, at least 6 feet away. It's recommended that in order to establish a healthy workplace environment, you follow CDC guidelines. And again, I'm sure many of you have already done this and are up to date on it. Hand sanitizer, hand washing. I'm a particular fan of Alton Brown's video on hand washing. It's a good one, but in any event, wash your hands with soap and encourage your employees to do so. We have a link here on the PowerPoint to the CDC guidelines for how to disinfect buildings. Most organizations have already cut down traveling except to the bare minimum, and frankly should be almost zero. Everyone is canceling on-site meetings and conferences, so there's probably not a lot of traveling that needs to be done at this point in time. Now, we talked about some governmental orders, governmental reasons, and they have come at a dizzying pace, dizzying speed. On March 18th, the governor issued Executive Order 202.5, which waived unemployment insurance waiting period of 1 week, directed closure of certain businesses. By the same day, there was the 50% order, the 50% reduction in on-site workers. The next day, 75% of all workers should stay home, and many institutions, such as barbershops and hair salons and tattoo parlors, had to close entirely. And then finally, not finally, but finally for our purposes here, Executive Order 202.8, which ordered that all non-essential businesses and not-for-profits, almost everybody, there are exceptions we'll talk about, have to telecommute or work from home to the safest possible extent and reduce the in-person workforce at any work location by 100%. In other words, everyone should stay home. The governor resisted calling this a shelter-in-place policy simply because that has certain other connotations dating back to the nuclear age, but it is essentially a shelter-in-place type of order. Now, certain businesses are considered to be essential, and an essential business can stay open, although they should still practice social distancing and limit the number of people who are on site at any one time. And you'll see there at the bottom, if you haven't already found that, there's a link to the executive orders that the governor has issued. I believe it's 13 of them on the COVID virus, just literally in the last 3 weeks. Now, what is an essential business? When this order first came out, colleges and universities were saying, are we essential? And the short answer is, unfortunately, no, generally. Although, we're lawyers, there are exceptions to exceptions to exceptions. The list of essential businesses that are contained in the executive order and in the guidance, and there's a link to guidance at the bottom of this page of the PowerPoint. Many of you probably already looked at it. are things like essential healthcare operations, hospitals, etc. Essential infrastructure, business, bridges and tunnels and utilities, essential manufacturing, essential retail, including grocery stores and pharmacies. We still have to be able to get our food and our medicines. Services, the news media, banks and related financial institutions. Again, I don't need to read through the entire list for you, but universities in and of themselves are not defined as one of the essential businesses that are able to remain open during this executive order. Now, here's sort of one of the exceptions, if you will, or a gloss on it. A business that provides service to an essential business, even if it's not in and of itself essential, can provide services. So for example, in our particular case, our law firm, we represent banks and utilities, among other clients, and they are essential businesses. So we are allowed to remain open to the extent only that we are servicing those clients, and not that we're servicing clients that would not fall into the essential business category. And even then, we have to try and maintain as much social distancing and safe practices as possible, and keep staff as low as possible. Now, there is a provision that in the executive order and in the guidance that says if a business wants to try and get itself designated as essential so that it can be exempted from this requirement, that there's a form that you can file online and seek to get an exemption. I know that in the first few days of this executive order, the state was swamped with such requests. Every business wanted to deem itself essential, or as many as possible. I'm not familiar with how many of those designations have proven to be successful. I know that some have. Maybe some of you on this call actually tried to go that way. And by the way, there are just going back, there are penalties if you don't follow the order. The local police and firefighters can monitor your business. There could be civil penalties of up to $2,000 per violation. And in fact, in a more recent executive order, the governor basically said the building department can come in and shut down your building, declare it to be a building code violation if you are open in violation of these orders. So it's to the extent that any of your operations are continuing, and I imagine for most of you, there are still some people, a small number of people who are on campus. Be careful about that and make sure you are reviewing the guidance and consulting with your legal counsel to make sure that you're not going to run astray, run afoul of the law. You've all heard also about this concept called Matildas Law. Matilda is Governor Cuomo's mother, and he named this after her. The first thing you should know about Matilda's Law is it's not actually a law. I've gotten questions from clients, including in the higher ed space, that like, how do we comply with this law? Do we have to send workers who are age 70 home and not allow them to work? And the answer is this: Matilda's Law is not a law. It is a series of guidelines that the governor has suggested to help protect those who are over 70, who constitute the most vulnerable population under COVID-19. But it hasn't been enacted either in an executive order or in a statute. The protections you can see there on the screen, and again, I think you're probably aware of it. So what we've advised is that if you have employees who are 70 or over, you don't have to send them home. You don't have to prohibit them from coming to the workplace. At the same time, if they ask to be excused from work, it's probably the better practice to do so. And you may want to voluntarily ask them to stay home without penalty. There are certain, shall we say, public relations issues involved if you were to be forcing some of your older employees to continue to work under these circumstances. And there are, particularly in the higher ed space, there are a lot of employees, I think, who are over age 70 who continue to work and provide valuable services to your institutions. So at this point, I'm going to turn it over to Hayley to discuss the financial impact to various institutions.
Thank you, Tom, and good morning, everyone. The COVID-19 pandemic has dramatically impacted employers of all sizes, but particularly colleges and universities. You know, Jim, Tom, and I were talking before this webinar about how it seems like we've been talking about this topic for years. But if you think about it, it really only has been a few weeks. You know, and it just by way of background, you know, the novel coronavirus, as everybody knows, originated in Wuhan back in December 2019. From there, an outbreak occurred in South Korea, Iran, Italy, through February 2020. On March 6th, nearly 4 weeks ago to the day, the University of Washington announced that it was moving to online instruction. And the University of Washington was really the first major university in the United States to take such action to support regional efforts to slow the spread of COVID-19. One day later, on March 7th, Governor Cuomo declared a state of emergency in New York, and that's when we began to see the New York colleges and universities move to online instruction and cancel in-person classes. A few days later, on March 11th, the WHO declared the coronavirus a pandemic. On March 13th, the US declared a national emergency. And here we are on April 1st, and New York City confirms over 45,000 cases, making it the epicenter of the outbreak in the United States. You know, I don't know how many of you subscribe to Governor Cuomo's COVID-19 emails, but every night he sends out a summary of the day and what has happened. And he ends these emails with a deep breath moment, thanking those who really went above and beyond that day. Last week, he thanked JetBlue for donating free flights for incoming medical volunteers heading to New York State. Another day last week, he thanked hotels for putting up first responders. So this morning, we'll start with a deep breath moment. As Jim mentioned earlier, we're in this together. Thank you to CICU for being a great resource. We'll all get through this. So in connection with COVID-19, many institutions are considering or have already considered reducing their workforces in connection with the interruption to operations due to the pandemic. As a general matter, we have two categories of employees: non-exempt employees and exempt employees. With regard to non-exempt employees, the Fair Labor Standards Act requires institutions to pay non-exempt employees at least minimum wage for all hours they work and at least time and a half the regular rate of pay for hours worked in excess of 40 hours. However, employers do not have to pay non-exempt employees who do not work. The FLSA only applies to hours actually worked. So if your college or university is not able to provide non-exempt employees with work while they're at home, you do not have to pay them for hours they otherwise would have worked. With regard to exempt employees are entitled to pay in any week in which they work. So if an exempt employee works 1 or 2 days out of a work week, they must be paid the same weekly salary. With regard to workforce reductions, if we have some time later on in the presentation, next slide please, we'll talk about the interplay of reduction and the CARES Act. I'll speak generally to workforce reductions, but to the extent you're considering financing under the CARES Act, you should look closely between the interactions between workforce reductions and the CARES Act. Generally speaking, employers can reduce the workforce for any reason other than an impermissible reason. So what is an impermissible reason? A discriminatory reason. You cannot terminate someone based on any protected class, race, sex, national origin, etc. You do not have to provide a reason for terminating or reducing your workforce. But the economic issues brought on by the state-mandated shutdown, stay-at-home work orders, etc., certainly provide a good reason right now. To minimize exposure, we're typically advising clients that they should do a pro forma analysis of employees selected for either a layoff or a furlough, and we'll go into how those two terms differ a bit to ensure that it can't be successfully argued that a college or a university or any type of employer selected employees on an impermissible basis. So what you want to do before you have any type of workforce reduction, classify the employees by gender, race, age, over, under 40 at a minimum. Just take a look at the workforce reduction that you're planning to do. So you have a few different options with regard to workforce reductions. Two frequently considered options are furloughs and layoffs. And we have a lot of definitions and terms being thrown around right now. So we'll go through the differences between both this morning. A layoff generally refers to when an employer terminates employment without any right to be recalled or reinstated if business conditions improve. And if a New York college or university decides to permanently lay off or terminate an employee, whether it's one person or 100 people, 100 employees, it has certain obligations to terminated employees. First and foremost, the employer must pay the employee's wages, final wages, by the next regular payday. Secondly, the terminated employee must receive a written termination notice. And this written termination notice must state two things. First, it must state the date that the employment ended. And second, it must state the exact date the benefits will end in accordance with the labor law. Your college or university, if you're considering layoffs, must also provide a COBRA notice. Unlike a furlough, benefits are typically terminated when an employee is laid off. Employees are entitled to healthcare continuation under COBRA, but that's usually at their expense during a layoff, unless an employer subsidizes it for a period of time. Vacation, we're getting a lot of questions about vacation right now. You're obligated, your college or university is obligated to pay out accrued vacation, accrued but unused vacation, in accordance with your stated policy. So this determination will largely fall on whether or not the employer's policy, your college or university's policy, states that you owe the employee payout of accrued vacation and sick time at the time of job termination. Severance pay is also not required in New York, but you want to take a look at, before considering any type of layoff or workforce action, whether it's written into a contract, but before doing so. Also, you want to take a look at your past practice. You know, some employers typically say 1 week for every year served, up to a certain cap. So take a look at what you've done in the past and if it's financially feasible now. And finally, when considering layoffs, you also must provide a notice, or when doing layoffs, you also must provide a notice of unemployment insurance. Typically, employees are entitled to collect unemployment insurance, but that is not the decision of the employer, it's the decision of the Unemployment Insurance Board. As Tom may have mentioned before, New York recently waived that 7-day wait period under the Executive Order 202.5, so there's no waiting period anymore for laid off employees. And in New York, the unemployment insurance benefit is capped at $504 per week. That now, according to the CARES Act, that will increase a little bit more, which we may get into later if we have time. Another thing to consider when doing layoffs, it's important that employers, colleges, universities are aware of their obligations under the federal and the New York State WARN Act. The New York State WARN Act is more restrictive, so that's one we'll review here today for time purposes. The New York WARN Act applies to employers with as few as 50 employees, and it requires 90 days advance notice of a mass layoff. A layoff affecting at least 25 full-time employees constituting at least 33% of the workforce at a single site of employment. Also a layoff of 250 employees or 250 or more employees regardless of the percentage at a single site. When doing a layoff, however, you want to look at it with a 3-month window, because that's how the Department of Labor will look at it. All employment losses in a 90-day period are aggregated. So if you do a layoff now and you do a layoff a month from now, the Department of Labor will consider that one for purposes of the WARN Act. One note about the WARN Act is that it is extremely dependent on particular facts and circumstances. The New York State Department of Labor recognizes that there are sudden and unexpected circumstances beyond an employer's control. In fact, it specifically references on the DOL website that the pandemic-related layoffs may be an exception to WARN. But again, these are highly fact-specific scenarios, and you want to consult with your local counsel on that. The second option with regard to workforce reduction, in addition to a layoff, is a furlough. We have a lot of questions coming in about furloughs. What is a furlough? A furlough does not have a precise legal definition. It generally refers to a mandatory period of time off without pay. It's essentially an unpaid leave of absence, except that it's initiated by the employer, whereas most leaves of absences are initiated by the employee. And we typically see these during periods of significant economic downturn and seasonal business cycles. Generally speaking, the employee will remain eligible for benefits. However, you want to check with your health insurance plan provider before you implement furloughs. Some plan providers will not allow for such. So again, check with your health insurance before you offer such to furloughed employees. While on furlough, employees may also have an expectation of reinstatement, and employers may have an expectation of reinstatement. Again, this should be a hope, not a promise to employees that are furloughed. Furloughed employees can generally receive unemployment as well. Again, this should be referred to the Unemployment Insurance Division. This is not a decision by the employer. The employer can give information about unemployment, but it's not a decision that's made by the employer. Importantly, and this is where a lot of colleges and universities, either have gotten into trouble or will get into trouble. Furloughed employees cannot perform any work while on furlough. So if an exempt employee performs work while on furlough, checking email from home or performing any other work, that college or university or employer needs to pay the employee for the full week. So you want to remove furloughed employee from all communications and really separate he or she from the institution. And no advance notice is required from furlough. So you have layoffs, furloughs. Your third option when it comes to workplace workforce reduction is a reduction of salaries. And employees are generally permitted to change pay rates. In accordance with the Wage Theft Prevention Act, however, you must give your employees 7 days advance written notice of their new rates, letting them know what their new rates will be and when those rates will take effect. And we typically advise clients, try to coordinate this with your payroll periods just for ease of reference. The fourth alternative, and this is really kind of a hybrid alternative to layoff, furlough, or reduction in salary, is New York's Alternative Shared Work Program. And we provide you with the website on the slides if you want to learn more about this program. Just in essence, though, employees work reduced hours and they receive their regular wages, the regular pay for those reduced hours, and then they receive partial unemployment from New York State for those other hours they would have worked. So the benefits of this program, it eliminates issues associated with termination, and it hopefully allows for quicker recovery after we get through this COVID-19 crisis. And with that, I will turn it back to Tom to talk about recent leave policies and paid sick leave.
Thank you, Hayley. So many of you are familiar with some of the leave policies that existed before the world exploded a month ago. And those would include the Family and Medical Leave Act, the New York Paid Family Leave Act, and employers' specific personal time off policies. The FMLA, as we all know, has been around since 1993, so 27 years. We've had time to digest its meaning and its effects. Probably everybody on this call has been covered by FMLA because it applies to any private sector employer with at least 50 employees, and it applies to employees who work at a location where there are 50 employees within a 75-mile radius. I would imagine that most colleges and universities have well over 50 employees. In order to be eligible for this, I'm briefly going through this simply to illustrate the differences in the new law. Employees had to have worked for at least a year, 12 months, had to have worked at least 1,250 hours in the previous year, and of course the 50 employees, as I mentioned. And the purposes for the FMLA: birth or adoption of a child, to care for a spouse, child, or certain family members with a serious health condition, the employee's own serious health condition, and certain military exigency leaves. We also know about the Paid Family Leave Act, the New York State Paid Family Leave Act, which is about 3 years old or so. And every employer in the state is covered by that. It doesn't matter how many employees you have. Well, even public employers are covered by it if they have opted into it. Even self-employed individuals can opt into this. And this also has certain eligibility requirements. You have to have worked more than 20 hours a week for 26 consecutive weeks, or at least 175 days in the previous year. And there's up to 10 weeks this year of benefits to employees for similar reasons to the FMLA, although it doesn't include the employee's own serious health condition. That's a different one major difference between those two laws. And employees can get 60% of their wages, and that's not paid for by the employer. That's paid for by the state through your disability insurance policy. Presumably, you have an add-on to your disability policy for that. And then, of course, many institutions and certainly many colleges and universities have personal time off policies, which are much more generous than those laws require. Now, after COVID-19 struck, there are two major laws that have been enacted, one on the federal level and one on the state level. First, on the federal level, you have the Families First Coronavirus Response Act, the FFCRA. New York has passed its own COVID-19 sick leave law. As I think I mentioned before, the FMLA has been around since 1993, about 27 years. The FFCRA was signed into law on March 18th, so that's about 2 weeks ago. Where everyone is learning it, everyone is trying to figure out all of the nuances, and the interpretations and the advice are coming out on this on almost a daily basis. In fact, just yesterday afternoon, the Federal Department of Labor published some regulations, and which includes a significant discussion of those regulations, 124 pages long. We're still trying to digest all of that. What does it provide? Essentially, it provides two different things. It provides for paid leave under what we call the Emergency Paid Sick Leave Act. And then there's also an expansion of the Family and Medical Leave Act, the FMLA. The Emergency Paid Sick Leave Act provides up to 80 hours of paid leave. So for full-time employees, you're talking about 2 weeks of pay. But it's only for reasons related to the coronavirus. And we'll talk about some of the details of that. And the FMLA expansion provides job-protected leave for up to 12 weeks, 10 of which have to be paid, which is different from the FMLA, as those of you with familiarity with the FMLA know, because that's unpaid leave. But again, it's a very limited expansion of the FMLA. There are refundable tax credits that are available to employers to help them pay for this. It doesn't have to come out of your pocket entirely. So if you violate these laws, there are penalties. Employees can sue you. The DOL can come after you. So it's obviously something that you're going to need to want to comply with. So at this point, I'm going to turn it over to Hayley to first start talking about the FFCRA.
Sure. So the Families First Coronavirus Response Act, that is a bit of a mouthful. So I'm going to refer to that as the Families First Act, or the Act. It, as Tom mentioned, is the new federal legislation that deals with sick pay. And it provides that eligible employers, and that means public agencies or private employers with less than 500 employees. So if your college or university has less than 500 employees, this applies to you. And it requires you to provide paid leave under certain circumstances. And in essence, what this legislation does is that it enables employers to keep their employees on their payrolls through tax credits, while at the same time ensures that employees are not forced to choose between their paychecks and the public health measures needed to combat the coronavirus right now and stop the spread. The law took effect yesterday, April 1st, and it sunsets on December 31st. As Tom mentioned, it consists of two main parts: the emergency paid sick leave, which provides 2 weeks of leave if one of 6 requirements are met, and we'll go through the 6 requirements briefly, and it's available on the employee's first day of employment. The second part of the FFCRA is the Emergency Family Medical Leave Act, the EFMLA, and that provides up to 12 weeks of job protected leave due to a need to care for a minor child if that child's school or place of childcare is closed due to the COVID-19 pandemic, a public health emergency. And employees are eligible for that leave after 30 days of employment. Additionally, all covered employers must post a notice in their workplace explaining these FFCRA leave rights. And we see that with many different federal and state laws, the notice requirements. Interestingly, though, recognizing that many physical workplaces are closed right now, the Department of Labor has addressed that and recommends, in fact, that you post this notice either on your intranet or by emails to employees, setting forth their different rights under the Families First Act. With regard to the first point, the first part of the Families First Act, the EPSL, again, this applies to colleges and universities with fewer than 500 employees, and it provides eligible employees with 2 weeks, up to 2 weeks of paid sick leave. Who is an eligible employee? Everyone. You're eligible on day 1 of employment. There's no length of service requirement, no hours work requirement. None of those issues are in play here. If someone works at your institution, they are eligible for paid sick leave, the EPSL leave, on day 1. Part-time, full-time, you're an eligible employee. Who's an eligible employer? Fewer than 500 employees. And you count whether you have fewer than 500 employees at the time the employee asks for the leave to assess whether you meet this threshold. There are 6 circumstances for which you can take EPSL leave. And we have a slide here that you can study on your own time after class today. It's your homework. We'll just briefly explain it here. The first 3 reasons pertain to the employee's physical health. If he or she is subject to a quarantine or isolation order. Number 2, if he or she has been advised by a healthcare provider to self-quarantine because of COVID. Or number 3, if the employee is experiencing COVID symptoms and is seeking a medical diagnosis. The latter 3 reasons have to do with whether if the employee is caring for an individual that's subject to a quarantine or isolation order, if the employee is caring for a son or daughter whose school or child care provider is closed due to COVID-19, and number 6 is kind of a catch-all by the Secretary, the HHS Secretary. How much leave do you get if you're an eligible employee under the EPSL? Full-time employees on the next slide, up to 80 hours of pay. Part-time employees, the average number of hours if the employee works over 2 weeks. If the average schedule is unknown, you use the 6-month average to calculate the daily average. With regard to those first 3 reasons, the employee must be paid at the employee's regular rate or the federal minimum wage or the state local minimum wage, whichever is highest out of those 3, to quarantine or seek a diagnosis or preventative care for the coronavirus. So those first 3 reasons, regular rate of pay maxes out at $511 per day, $5,110 in the aggregate over a 2-week period. The second 3 reasons require payment at 2/3 the employee's regular rate or federal minimum wage or state local minimum wage, whatever's highest, the up to $200 per day and $2,000 in the aggregate. And again, there are quarterly tax credits to offset employer payments. And with that, I think we'll go back to the second part of the emergency, or we'll move to the second part of the Families First Act, the EFMLA, and we'll turn it back to Tom.
Thank you, Hayley. Before I begin this section, I just do want to emphasize something that Hayley mentioned, that this law applies to employers of under 500 employees. Some of you, I know, have more than 500 employees. So in that case, you are not covered by these laws. And by the way, when we count employees, that includes full-time, part-time, temporary employees. They all count towards this 500 employee number. Also, if you have more than one campus, but it's all under one umbrella, they all count. So if you have any questions about whether you are or are not covered by these laws, again, review the regs or consult with your counsel. Now, the second part of this law, and we're starting to run up against time here, is the EFMLA, the Emergency Family and Medical Leave Act. And what it does is it expands the existing FMLA in a very specific and narrow way. This is for people who are unable to work or telework for a qualifying need related to a public health emergency. We are, of course, in a public health emergency right now. You have to have been on staff for at least 30 days in order to be eligible for this. It became effective yesterday, and it sunsets on December 31st, unless, of course, Congress decides to extend it again. Now, the only reason that you can take EFMLA is if you, again, unable to work or telework in order to care for a minor child, if the child's school or place of childcare has been closed or is unavailable. So that's it. That's the only reason that EFMLA benefits apply. So if you have an employee who has a child who's home, and frankly, all of the children are home right now, that's the reason why somebody can take this kind of leave. The first 2 weeks of EFMLA leave are unpaid, although you can supplement the pay using benefit time if you wish. The last 10 weeks are paid. One important note here, this is not in addition to the 12 weeks under the traditional FMLA. It counts against those 12 weeks. It's a total of 12 weeks. And then, as you can see on the slide, pay is capped at $200 a day and $10,000 total. There is a small business exception for employers of 50 or less. It's probably not going to apply to people in the higher ed sphere, but if you do represent a small institution, that's something that you should look at. As in all of these laws, there are reinstatement rights. These leaves would not mean much if you could say you can take the leave, but you don't have your job back. You must restore the employee, just like under the traditional FMLA. If you have to lay somebody off, if your affairs and your business have been affected to the extent that you cannot rehire employees because you've reduced staff and you no longer need the employee, there are steps that you need to take to try and find them a job, and it's outlined here on this slide. Now, New York also gets into the act. Why should this be simple? New York signed a law that was effective on March 18th, and you have to provide leave and certain other benefits to employees who are unable to work or telework and are subject to mandatory or precautionary orders of quarantine. Now, this is important. I've had employers ask me, well, the state says stay home, you can't work, or the company can't work. Is that a mandatory order of quarantine or precautionary order of quarantine? And the answer is no, it is not. If the Department of Health orders people, certain individuals, to stay home because they are either sick or they have been exposed to someone who is sick, that is covered. But the general stay-at-home order that the governor has issued is not covered by this law. There are some exceptions for employees who traveled to CDC level 2 or 3 countries, even after they had been told not to. We won't get into that. And by the way, that same rule applies to the federal law. In other words, the mere fact that the governor has ordered businesses to be closed is not an order of closure that covers you under the federal laws. It's only when there's a specific order relating to a specific individual that the federal law is implicated. The type of leave, the amount of leave, and whether it's paid varies under the New York State sick leave law, assuming it applies. Larger employers have to give at least 14 days of paid sick leave. Again, this is for employees who have been subjected to a quarantine or isolation order, presumably are either sick or have been exposed, and there's a 14-day incubation period that you have to pay for. For smaller employers, the requirements are less. And again, you can look at the details of this slide at your convenience. During that type of sick leave, employees have to be paid at their regular rate of pay. They're entitled to reinstatement, cannot be retaliated against, etc. There's probably nothing new here. Those of you who happen to be located in New York City, well, there's the New York City Sick Time Act also. We're not going to go over that, but there are additional sick leave rights under the New York City sick leave law, which have to be taken in connection with all these other laws that have been applied. At this point, I'm going to turn it over to Jim, who started this program, who's going to talk briefly about the CARES Act and how that affects you.
Thanks, Tom. These guys do this to me all the time. We have 6 minutes left to talk about an 880-page new law. So one of the things I think you're most interested in, and we'll get right to it, is with unemployment benefits. New York State, as most of you know, you can get up to $504 a week for unemployment. Under the CARES Act, they tack on an extra $600 regardless of income. So if you're entitled to the $504, you will be eligible to receive $600 more for a total of $1,104 a week. If you recall, the Senate held this bill up for a couple of days because, for example, Alabama, the maximum unemployment benefit was $275. Lindsey Graham was saying people would be incentivized to go on unemployment and stay home because they'd be making $875 a week. That's true. That's specifically designed to try to make people whole. So it's in New York, it's $1,104. If you have cut back hours but not terminated people, New York State has the shared work program, where you pay effectively, for example, you pay somebody for 3 days of work, the state kicks in 2 days of work of unemployment pay. It's not full. It doesn't match dollar for dollar the lost salary. And there's an issue, quite frankly, whether they would be entitled to the extra $600 for unemployment since they are receiving an unemployment benefit or some percentage thereof. We're looking at that as we speak to confirm whether that benefit would apply, but it's obviously a tremendous benefit. The $600 runs through July 31st. And also, you should know that New York generally offers 26 weeks of unemployment. The new law adds another 13 weeks to that through December of this year. So that's unemployment in a quick nutshell. I do want to talk about the loans available because of all the hardships we all are facing. The big one, obviously, that you've all heard about is the PPP program, the Paycheck Protection Program. That's the forgivable loan program, which I really invite you to look at if you have 500 or fewer employees. Part-timers count, adjuncts count. So you really have to do a full count of your employees to see if you're eligible. You can take out the lesser of $10 million or 2.5 times your total payroll costs for a 1-year period. So you want to really get into the nuts and bolts of this because it is a tremendous program that essentially allows you to take out this loan. It's a maximum of, as I said, 10 million at 4%, but if you use it to preserve jobs as it's intended, most, if not all of it, could be forgiven. So that's a tremendous program that I invite you to look into. The other program, if you're over 500 employees, the loan is not forgivable, but it has a maximum cap of 2%. And right now, it went out at 0.05%, so it's essentially free money. The first 6 months are no interest or principal payments are due, so you don't have to make a payment for the first 6 months. And then it's designed as long as you retain 90% of your workforce at full wages and benefits through September 30th of 2020. Thank you all very much.